Well, hello, and thank you for taking the time to watch this 15-minute snapshot on patent grace periods in New Zealand and Australia. My name is Duncan Joyner. I'm a Senior Associate and Patent Attorney at Phillips Hillman Fitzpatrick, working in our firm's Engineering Technology Group. Now, my practice focuses primarily on the preparation of new patent applications and the prosecution of overseas originating patent applications. And as part of this, I'm sometimes required to consider the effect of an earlier disclosure made by the client prior to filing their patent application, or to respond to a prior art objection raised during patent examination in which the applicant's own prior art document has been raised as prior art. Now, in either of these situations, it's important and worthwhile considering whether there are applicable grace period provisions which may assist the advancement of the client's patent rights. And so the purpose of this snapshot is to provide a hopefully helpful summary of these provisions in Australia and in New Zealand. So firstly, what are we talking about when we refer to a grace period? Well, in broad terms, a grace period is a period of time preceding the filing of a patent application during which certain disclosures will not constitute prior art against the patent application. Now, many, or in fact most countries, have provisions dealing with unauthorised or abusive disclosures, but some countries, notably the US, but also Australia and New Zealand, have more generous provisions which not only allow for the disregarding of abusive disclosures, but also for the disregarding of intentional disclosures. And so consequently, in Australia and New Zealand, valid patent rights can still be achieved despite the filing of a patent application after an intentional disclosure. And the grace period provisions may also allow for certain prior art to be overcome if it's raised against the application during the examination. So looking firstly at Australia's grace period provisions. Australia's provisions are essentially split, will cover two types of scenario: disclosures made with consent and disclosures made without consent. But in either case, a complete application is required to be filed within 12 months of the disclosure. And this is also satisfied by the filing of a PCT application designating Australia, and in which case an Australian or the Australian National Phase Entry would gain the benefit of the Australian grace period provisions. Some examples of with consent, of a with consent disclosure would be disclosing an invention on a website, arranging for someone else to publish the invention, disclosure of the invention to a commercial partner or potential commercial partner, disclosure of the invention by use or commercialization, including sales, and notably Patent Office publication of the applicant's earlier patent application. That's taken to have occurred with consent, and so would fall within the with consent provisions in Australia. Some examples of without consent disclosures: someone taking and publishing my invention without my consent, let's say a former business partner or manufacturer or an employee, anyone who has derived the information from me. And it also covers a chain of disclosures which leads to a third party, including third parties that are unknown to me. So long as you can show that the information has been derived from you, then potentially Australia's grace period provisions would cover that third party disclosure. And the without consent provision would also cover someone taking my material and filing their own patent application, which is then subsequently published by the Patent Office. A couple of short examples, timeline examples of how this works in practice. In the first example on the slide, an inventor has self-disclosed their invention on the 12th of April 2022. If then a complete patent application is filed in Australia, which could be a PCT application, then that's filed by the 12th of April 2023, then that inventor's disclosure will be disregarded from the novelty of inventive step assessment for that Australian complete patent application. In the second example, during examination of a complete Australian application filed on the 17th of February 2006, the examiner has raised a prior art citation which was published on the 1st of September 2005. So that's less than 12 months before the filing date of the application that's under examination. Now, in this instance, if that citation was owned by the same applicant, it's presumed to have been published with the consent of the applicant, and therefore it can be disregarded under the grace period in Australia. Now, the same is true if that citation was not owned by the same applicant, but if it could be shown that the information in that citation had been derived from the applicant. For example, if the citation had been filed by a former employee or a business partner with access to the applicant's information. Now, there's no deadline to file to invoke the grace period in Australia. You may simply point out to the examiner during examination, let's say in response to an examination report, say that the citation you believe falls within the grace period provisions and request that it's withdrawn. Now, in some instances, an extension of time can be awarded by the Patent Office if the 12-month deadline to file a complete application has been missed. There's a couple of Patent Office decisions where that has been allowed. The requirement for an extension of time in Australia was that there was an error or omission which has led to the missed deadline. But in some instances, if you're able to show that you would have filed a complete application within the 12-month window or 12-month deadline, but for the error or omission, then you can request an extension of time, and potentially the grace period provisions may still apply despite filing your complete application after 12 months. Now, the main limitation associated with relying on the Australian grace period provision comes from our section 119 of our Patents Act, known as the innocent infringement provision. And this provides that there is no patent infringement if a party was exploiting an invention or had taken definite steps to exploit the invention before the priority date of the patent claim. And so if you consensually disclose information and then subsequently patent it under the grace period, there'd be no infringement if a competitor begins exploiting the invention before the priority date. So an example of this in practice may be if there was a trade show and a new product was disclosed at a trade show, every passerby could potentially copy that product, and provided that those passers-by had taken definite steps to exploit that product prior to a patent application being filed by the exhibitor at the trade show, potentially all of those passers-by could be immune to any future claims of patent infringement. So turning then to New Zealand. New Zealand has relatively recently, in 2018, introduced its first ever grace period covering intentional disclosures. New Zealand already had provisions covering abusive disclosures, disclosures made unlawfully or in breach of confidence, but before 30th December 2018, an intentional disclosure in New Zealand was not covered under any grace period provisions for New Zealand. However, as part of New Zealand's accession to the CPTPP trade agreement in 2018, New Zealand now has this new section under 91F, and that's up on the slide, and that's a relatively similar provision to Australia. Covers disclosures made intentionally by the applicant, provided that a complete patent application is filed within 12 months of the disclosure. Some things to note about New Zealand's grace period is that it does not apply to any disclosures made before 30th December, and that's regardless of when the patent application is filed. And like Australia, it requires a New Zealand complete application to enliven the provision. But a PCT application which designates New Zealand, that's okay. Unlike Australia, it requires the applicant to file a statement setting out the details and the dates and the particulars of the disclosure. That statement could be filed sort of preemptively, for example, when requesting examination, or it could simply be filed in response to an examination report. Some limitations associated with the New Zealand grace period, well, being that it's relatively new, there are sort of some questions that remain as to how it will be interpreted and applied by the New Zealand Patent Office or New Zealand courts. And one question in particular is how it will deal with disclosures that were made without express consent, but which were not abusive disclosures. And this is because New Zealand provisions cover third-party disclosures made unlawfully or in breach of confidence, and they cover third-party disclosures made with consent. But it's not exactly clear that the provisions would cover a third-party disclosure made lawfully, but without the consent of the applicant. And so the example that's sometimes used for this, the conference attendee publishing an article on a talk or a presentation that they heard at a conference given by a soon-to-be patent applicant. Now, this is probably not an unlawful disclosure to write an article about something you heard publicly delivered, and it's probably not a breach of confidence either. But if the article is to fall under the New Zealand grace period provisions, then consent of the applicant is required. And in this circumstance, the author of the article could be totally unknown to the applicant. And so under a literal reading of New Zealand's provisions, it's possible that the attendee's article wouldn't fall into the provision of the New Zealand grace period provisions. And perhaps unless there was some sort of implied consent for republication, if you assume that, then perhaps it might be okay. But this is one of the unknowns associated with New Zealand's grace period, which is likely to be dealt with in due course by the Patent Office or some court decisions. Now, it's worth mentioning that this wouldn't be a question in Australia. In Australia, the attendee's article would be clearly disregarded under Australia's grace period provisions because Australia's provisions simply require that third-party disclosure was derived from the applicant, but there's no requirement that it was either made unlawfully or that it was made with consent. But the position's a little bit less clear in New Zealand. So some take-home points about the Australia and New Zealand's grace period provisions. In a nutshell, a complete application that is filed within 12 months of a disclosure or a citation published with the consent of the applicant, those can be disregarded from novelty and inventive step assessment. And a PCT application designating Australia and New Zealand is sufficient to count for a complete application and enliven the provisions. So consequently, in Australia and New Zealand, some patent rights may still be preserved where a disclosure has occurred prior to filing. And during prosecution in Australia and New Zealand, where a citation is owned by the same or related entity, discuss with your patent attorney whether or not the grace period might be invoked. Well, thank you for taking the time to watch this snapshot. And if you'd like any further information on the operation of Australia or New Zealand's grace period provisions, please feel free to contact me or contact any of our patent attorneys at Phillips Norman Fitzpatrick.